Thank you for tuning into this segment of our recent workshop, 10 Things I Wish I'd Asked My Lawyer. In the next video, George will answer the question, my son and his friends got into Larry's liquor cabinet at his birthday party. I know how much trouble they're in, but just how much trouble am I in? Enjoy the viewing.
Now, rather than raucous parties at Larry's house, I want to talk to you about Bill and Cynthia Burnett, who were arrested in 2011 after they hosted a party for their son's football team. End-of-season party. Bill and Cynthia were as conscientious as anyone could be. Now, you may have heard about Bill and Cynthia. Bill is a Stanford University professor, and this story received some national attention. These people did everything right. They told all of the guests no alcohol. They patrolled the party continuously. And yet, you know these teenagers, they're really sneaky. They brought booze into the house, and an anonymous call to the police brought the police because they had heard about underage drinking at the Burnett house. They found the teenagers drinking. They arrested the Burnetts. A 6-month investigation followed before they were finally acquitted. The DA finally dismissed the charges after 6 months. Now, they were extremely lucky. First of all, they did everything right. And second, no one got hurt as a result of the things that occurred at that party. The minefield is particularly tricky for our children. Let me give you 3 examples. My 17-year-old daughter visits a schoolyard during the summer in the evening with one of her friends, passes a joint to that person. If my daughter is arrested, she's committed 2 felonies. Distribution of a controlled substance, 1 to 5 year sentence, and possession of marijuana within a school safety zone, even though it's in the evening, even though it's in the summer months. Punishment up to 20 years in prison. My daughter has a valid prescription for Tylenol 3. During school, she has a friend who's not feeling well. If she gives one of these prescription pills to her friend, she has committed a felony. The felony is distribution of a Schedule III drug, punishment 1 to 10 years in prison. Your 17-year-old son is dating my daughter. She looks 17. She tells him she's 17. In effect, she's 15. If our children have sexual intercourse, your son is guilty of statutory rape, even though he was misled, it was an honest mistake. And he will be guilty of statutory rape. Now, statutory rape may be the least of our problems, because when my wife finds out about this, there is going to be hell to pay. As a general rule, persons under 17 commit delinquent acts. That means that they go to juvenile court, the penalties are misdemeanors, and they are probably expunged from their record when they become adults. But at 17, on your 17th birthday in Georgia, you become an adult for criminal purposes. So any crimes are prosecuted as adult crimes. The convictions follow you during your entire lifetime, and it can be a serious tragedy for our children. The arrest, even an arrest, is a disclosable item on a college application and a job application. So when a 17-year-old gets arrested for doing something, that's something that they have to disclose, and it will follow them potentially for the rest of their lives if you don't go through the effort of having it expunged. Larry? An exception exists in Georgia for the 7 deadly sins. For these crimes, any person 13 years or older can be prosecuted as an adult. It's up to the discretion of the district attorney, and it depends on the seriousness of the crime. The stuff gets pretty graphic, and I don't want to offend our sensibilities, but I want to define just a couple of these terms so that we understand clearly what we're talking about. Felony murder, for example, is an accidental murder. It's a death that occurs during the commission of a felony. So if a child is engaged in something that is felonious, and as an inadvertent consequence of that action, they can be charged with felony murder. Sodomy in Georgia is oral or anal sex. Now, we have a president to thank for the fact that there is a much broader conversation about oral sex than we ever imagined, I ever imagined in my lifetime. But it's a conversation that our children actively have. Aggravated sodomy occurs when a person forces another person into an act of sodomy. Now, I'm going to skip the definition of the other things, but let me tell you about the Romeo and Juliet law that exists now in Georgia. If a victim is at least 14 years of age but less than 16, And if the partner is 18 years or less, and there is less than 4 years difference between these parties, then a consensual crime will be adjudicated as a misdemeanor, and the punishment will be no more than 1 year, will be up to 1 year in prison. The law was adopted following a highly publicized case involving a 17-year-old male and a 15-year-old female who had consensual oral sex. And as a result of that case, the jury found the male not guilty of rape, but he found him guilty of aggravated child molestation. 10-year minimum sentence. A conviction that will follow him as a sex offender for the rest of his life. Today, with the Romeo and Juliet exception, the 17-year-old man would be prosecuted for a misdemeanor and his sentence would be no more than 12 months. However, the aggravated child molestation charge would follow him for life and he would still be branded as a sex offender even though the crime is a misdemeanor. Next slide. Once again, I want to emphasize the prosecution ages in Georgia. As young as 13 for certain acts, and a child can be prosecuted as an adult. On our children's 17th birthday, they become adults for criminal purposes. Okay, clear. Alcohol in the breath of a person 21 years of age, younger than 21 years of age, constitutes the crime of possession of alcohol. You don't have to have a container in Georgia. You don't have to be caught with a container. Simply having alcohol on your breath is considered to be possession of alcohol by a minor. There are exceptions to that law. For example, alcohol used in religious ceremonies is an exception, and also alcohol which is provided by a parent or guardian in the parent or guardian's home to a child who consumes that alcohol in the presence of the parent. So it's interesting that parents can provide alcohol to minor children in Georgia. That is an exception to the underage consumption law. But let's talk for a moment about an adult's liability where we do have a minor consuming alcohol. For example, a parent of a high school student has a friend over and the parent provides beer on this sleepover event. The parent has committed a misdemeanor. A college social organization has a kegger and a 17-year-old is serving beer and there is an under 20-year-old person participating in the party. That 21-year-old has committed a misdemeanor. The misdemeanor has a punishment, the punishment for this misdemeanor offense is up to 12 months in jail. However, significantly worse than the punishment is the potential for liability for the damage that may be caused by that underage minor. If you serve alcohol to a minor and the minor damages property or injures a person, the adult that provided the alcohol is responsible in the state of Georgia. Did you know that possessing a false identification can be either a misdemeanor or a felony in Georgia? After 9/11, the possession of a false identification bearing a government logo or government indicator was absolutely a felony. In 2008, the legislature modified the law to make it a misdemeanor as long as the person presenting this identification is under 21 years of age and that identification is used to obtain entrance to a bar or a nightclub or to purchase alcohol or cigarettes. But in any other instance, the possession of false identification bearing a government logo, so if the person is over 21 years of age or if it's used, for example, to rent a car, to cash a check, or for other purposes, it's a felony. So false identification is a big issue in Georgia. We had a client who was working on, a Canadian fellow, was helping his daughter with, the whole family was immigrating into the United States. The application was pending. The daughter was a tech student, came up someplace with a false ID to enter a bar, and was caught. And the father was horribly concerned that it would affect the immigration application. So possessing a false identification document is a serious offense in Georgia.
We hope you enjoyed that video segment. Other questions that were answered at a recent workshop can be located on our website at our Education and Resources page. Our website address is www.MendenFreiman.com.
For additional information about these topics or our firm, please contact us through our website or call our office at 770-379-1450. We look forward to hearing from you.